the leader of the National Colored Congress, Mr. Fadiel Adams, appeared in Pinetown Magistrate Court yesterday, on the 13th of May 2026, for his bail application. It seems as if Mr. Fadiel Adams' past has came back to haunt him. They spent the whole day in court. The first part was the state reading the affidavit of the investigating officer into the record. They've read the whole affidavit. I won't attach it here because at the moment we are not speaking about the merits of the case, but we are on the application of bail or bail application. Please subscribe to the channel, it's free. Like the video and share your thoughts in the comments section below. When the state was done with reading the affidavit of the investigating officer, they took a break. When they came from break, then the defense, meaning Mr. Adams' lawyer, read the affidavit of Mr. Fadiel Adams. You will recall that last week, the state changed their mind because of Mr. Fadiel Adams' attitude. They were not opposed to bail, but later on they said they've changed their mind, so they want to present the reasons why they are opposed to bail and requested to be given time. Before they read Mr. Adams' affidavit, this is what the state prosecutor said.
Some of the claims made by the applicant, as far as the generals of the South African Police Services are concerned, have been investigated and were found to be baseless. The applicant claims in his video clips that were played in this honorable court, that General Dumisani Khumalo was behind the killings of Cindy Somakang, and as such he has interviewed the hitman Sbusiso Ngengwa for the purposes of exposing this fact. 3, I went to check and have a look at the statement he obtained from Sbusiso Ngengwa on the 24th of January 2025, and therein I could not identify any mention of Lieutenant General Dumisani Khumalo as being behind the killing of Cindy Somakang. See attached statement marked SM7 and 8 respectively. Paragraph 4, records will reflect that Lieutenant General Dumisani Khumalo in the year 2017, when Mr. Cindy Somakang was shot and killed, he was reporting under SAPS Division, Operations Response Services, and not crime intelligence, as portrayed by the applicant. Only during the year 2018, when the Political Killings Task Team was established, General Dumisani Khumalo led this team and ensured that the hit orderers, hitmen, coordinators, spotters, murder weapons, as well as other exhibits were secured for the successful prosecution of this matter, and that is public record. It was only in December 2022 when General Dumisani Khumalo was appointed to head Crime Intelligence Division. I therefore plead with this honorable court to disregard all the utterances and claims made by the applicant, since they are baseless, defamatory, and lack any reasoning, either in fact or in law. I know and understand the contents of this statement. I have no objection to taking the prescribed oath, and he considers the oath prescribed to be binding on his conscience. It was properly commissioned. I will not proceed to read into the record the SM7 and SM8. Safe to say that they form part of the record.
Thank
May
you.
I please the court?
There's a criminal case open against Mr. Adams. Because, honorable chair members, and again, what became known, what made Merity House and many people start making noise, including Honorable Adams about PKTT and the case of Cindy Somakang. The obsession with General Khumalo and wanting to manipulate that everything is about General Khumalo, that blinded them. Khumalo arrested the criminals that killed Makata, that planned and organized and killed Makata. He arrested them. Khumalo discovered that the resources that were used came from crime intelligence. A parallel investigation is running for that purpose. But Kumalo is blamed for the death of Mugabe. So because their members are trying to drive a different narrative. So, and then the member of parliament, Mr. Adams, doesn't pause to analyze this. Had he done that, he was going to get the facts and be able to realize that I'm now interfering with the police operation by going to this criminal that is convicted and getting some statements and trying to paint a different picture. So these are just but one example of many of those instances.
Listen here so that you'll know the reasons why the state is saying Mr. Fadiel Adams shouldn't get bail. The matter was postponed to Friday, May 15, 2026.
Your Worship, I just want to start with paragraph 9 of Exhibit D. This comes on the wake of a letter which is attached on Exhibit B as SM email 1. If I can go to the 8th page of SM email 1, Your Worship. This is a letter that was written by Attorney Shahid Schroeder on the 9th of April 2026 to the Minister or the Acting Minister of Police, which is referenced on the applicant's affidavit. We need to understand the timelines and in the process try to remove the confusion, self-made confusion by the applicant. An email is sent by Mr. Schroeder in the beginning of April 2026, whereby the applicant is saying, should the PKTT have a J50 on my name, let me know, I'll hand over myself. Well said, nothing wrong with that. Now, he says in 9.1, from paragraph 9, there was a confusion. He didn't trust this warrant. He had to rush to court to go to court order because there was confusion. And it appears, Your Worship, the confusion is made by an email that is sent by the office of Lieutenant General Mkwanazi on Sunday, the 3rd of May, which is attached as FA4. Can we read FA4 properly so that we show the self-imposed confusion by the applicant? Morning, General. I've heard that you are looking for Mr. Adams, PM, and thought that I must share this letter, which was emailed to the Acting Minister of Police, and the copy was sent to me in April 2026. It starts like that. But the applicant chose not to put this part, or this portion of the email, on paragraph 9.1, because the next paragraph talks to the previous paragraph. It says, in receiving this email, which email? The email that was sent was where it was copied when it was sent to the Minister of Police. That is the email he's talking to. In receiving this email, I made inquiries. The email would have been sent on the 9th of April 2026. Then he made inquiries. He was copied, as he says, on the first paragraph. Major General, which letter was emailed to acting minister and copy was sent to me in April 2026. The confusion is saying this he received on the 3rd of May. That's not true. When the minister was sent an email by the applicant's attorney, the Lieutenant General Mkonazi was copied on it. And upon receiving that email, he made inquiries to the team of the prosecutors about this warrant. And he was informed, properly so, and truly so, that there was no warrant at the time. Because the warrant was only signed on the last day of April 2026. It's attached. Who's confused? Self-made confusion. Let us remove the first paragraph so that the context to the court must not portray the true reflection of what transpired. Therefore, his paragraph 9 up to paragraph 14 is a self-made confusion so as to justify his fugitiveness, which I'm going to argue later on. There was no confusion at all. General Mkonazi's email is clear. I'm sharing what I was copied on the 9th of April. Therefore, confirming, you can speak to the lawyer because there is this letter. I just wanted to start there, Your Worship. Let us again, in the same breath, understand the court order. Which he says, I had to run to court because there is this confusion. I didn't trust anyone. And they attached the court order. If I can just get the copy thereof, Your Worship. F5, FA5. If the applicant was honest and understood the email as it is portrayed, there was no need for this. FA5. Ex parte application. Paragraph 7. That a rule nisi is issued calling upon respondents. The respondents here are the Acting Minister of Police, Lieutenant General Nhlanhla Mkhwanazi, Provincial Commissioner of KZN, Lieutenant Colonel Machila, the Deputy Police Commissioner and Acting Crime Intelligence, Detecting rather. I don't know whether that is his post. That a rule nisi is issued calling upon respondents to show cause, if any, within 24 hours of the service of this order, to the above Honorable Court why the respondent should not comply with the order. It is not saying comply. It's saying show a reasonable cause within 24 hours why you should not comply. Now, it is argued that the PKTT did not comply with this order, unconstitutional. All that they needed to do is to go to court and show cause as to why they should not give the J50 to the applicant or his attorneys. Let us understand the perspective of that order. And it does not in any form or manner say, do not arrest this man. It's not saying that. I'm looking at it. Do not, no, there's nothing there. Hence, Your Worship, I'm saying there was absolutely no need for this court order. In the contrary, the applicant was trying to delay as much as possible his arrest. And in the meantime, calculatively made sure that I always do press conferences in the precinct of Parliament because his labels under the impression, PKTT won't touch me there. He said it in the video that we played this morning. That these people are acting unlawfully, they went into the parliamentary precinct and all of that. They were not supposed to be there. I will argue this further when I deal with section 60, subsection 4. Perhaps let us start there. I am not member of parliament, neither are my colleagues or police. We simply interpret and understand the law as it is indicated. Section 60, subsection 4 of the Criminal Procedure Act 51 of 1977 says, the interests of justice do not permit the release from detention and an accused where, 1, or more of the following grounds are established. You only need one, Your Worship, to be established, that you should deny bail. There's a bonus of saying if there's more, you can consider. It is my request to start with 4B and 4C before I go to A and D. These are the words that are used. It's not my words, the legislature's words. Where there is likelihood that the accused, this is now 4B, Your Worship, if the accused, if he or she were released on bail, will, can we underline the next word, will attempt to evade his or her trial. Not that he will, if it can be established that he will attempt to evade his or her trial. What do we have here? We have an applicant who knew as early as Saturday the 1st of May, the 2nd of May. Oh, by the way, the 1st was Workers' Day. The 2nd of May. Hey, there's a warrant for me. He did not stay in his houses. Instead, he went and posted video footages for the whole country to know that he can act better than Harrison Ford. Harrison Ford was a fugitive from justice in the movie. He says, that man, I'm better than him. He told everybody. Not that he will evade. He will attempt to evade justice. I've already mentioned, Your Worship, that he calculated his moves to be always in the parliamentary precinct. That is where he was arrested. He confirms it. Because he's labeling under the impression that they won't touch me there. Is that not an attempt on its own? That is what the law said must be established. The court order, self-made confusion. He goes on the video footages and say, I'm aware they went to this address, they went to this address, they went to my sister's address. Hey, these people, 150 million budget, they can't find me in Cape Town. He says that. We all listened this morning. And then in his bail application, he brings proof of residence. That does not carry his name. I went through that document thinking, Mr. Adams' name will be there on the deed. Maybe his initial is, or his, maybe as a witness, nothing. It's the name of his wife. The wife, he says to this court, I was married to her for some time and we got divorced. We just remarried. But with that history, trust that her address is mine, even though my name is not there. He goes and confirms an address in Parliament. It's not his address, for God's sake. He attaches a letter from the from the Department of Public Works. By virtue of his party having appointed him to represent the party in Parliament, he stays in that address. If the party tomorrow says, Mr. Adams, vamos, he ceases to be a resident in that address. We don't need to prove or establish that he will evade. We can only do so by saying he will attempt to evade. We believe we've established that. Your Worship was addressed about the conduct of the applicant on his first appearance by Mr. Mata as to why the state's attitude changed. There was a reason why we played all these video clips this morning, so that the court cannot hear it from me or from the state as to how Mr. Adams conducts himself. From the horse's mouth, saying all kind of things. Important for this bail application. On one side, the accused, I'm prepared to hand myself. I even wrote a letter to the acting minister. Now the police say, come. As we're taking your invitation, come. He goes there, he goes there, he goes there. Every time he goes, disappears, comes in, disappears, comes in, holds a media briefing and tell everybody how best he can escape the police. Better than Harrison Ford. On Exhibit E, he says, Your Worship, paragraph 3, the last sentence. I was satisfied. I deny refusing to cooperate with Colonel Mashele and admit declining his offer to drive me to the police station. Excuse me. As I was satisfied that there was a warrant and was happy to hand over myself. How was he satisfied? Because the very same PKTT at the gate of the precinct showed Mashele the warrant and he showed it to him. Something that could have been done as early as the 2nd of May. it did not need a court order to execute a warrant, show it to the one who's going to be arrested. You don't post it to the lawyer first and then it goes to somebody else and then it... No. Show it to the one who's going to be arrested. That's how it's supposed to be effected. He then goes on to say, my surrender can be confirmed. I was looking at Mr. Kangai thinking when I assist with the reading of this word. Confirmed by both SAPS members and the camera footage. I request this court to go and look at the footages, maybe from one of the members here. You'll be shocked to see Mr. Mashele actually grabbing the applicant. Grabbing the applicant. Let's go. He has invited you to do that. It's not us, it's the applicant. No, go and look at the footage. You'll see that. That is the aspect that we wanted to lead as a supplementary based on what he raised here, Your Worship. But as Mr. Adams has said, you can, then Your Worship can. 4C. We've established one. Submit. Now we're giving Your Worship a bonus of saying no. There's more. Where there is likelihood that the accused, if he or she were released on bail, once again, will attempt to influence or intimidate witnesses or to conceal or destroy evidence. Will attempt to influence, will attempt to intimidate, will attempt to conceal, and will attempt to destroy evidence. SM6. I'm reading from paragraph 2. On Sunday, the 3rd of May, 2026, at about 1500 hours 03, I received a WhatsApp video message from Mr. Fadiel Adams using number blah, blah, blah. Request that he needs to talk to me very urgently. It's not the witness who called Mr. Adams. It's Mr. Adams who initiated the process. He is aware, he has told us on the video, that the police officers of the PKTT are looking for me for having taken a statement from a hitman in prison. He's aware. And therefore, the person who assisted him to do so is a potential witness. He then starts initiating the process. This was followed by a WhatsApp voice call at 15:15, which I did not answer. Then on Monday, another day. We tried on the first one, we go to another day. Can we look at this? The 4th of May at 12:05 at night. This man is not sleeping. 00:05. Mr. Fadiel Adams calls me again on WhatsApp, and I did not answer. We are not establishing him having influence, him making an attempt to influence. Paragraph 3. On the 4th of May 2026, he then called again using WhatsApp. I did not answer. Due to the volumes of calls I was getting from him, at 10:11 I then decided to call him back using my WhatsApp. There was an indication earlier on, Your Worship, from the affidavit of the IO that the attorney, Mr. Schroeder, said the applicant keeps on changing his numbers. This is evidenced by Mr. Adams making a video call to this witness. It's me. Don't worry. It's me. This is attached on SM7. So that he can show faces to, you might not have my number. Don't worry, bro, it's me. There is no at all doubt that he made the call, because it's him on the video to the witness. It's him, whoever touched it. Now, I asked him why he was calling me and warned him that he has to put me into trouble. Paragraph 4. There's a warning from this witness. Menier, stop. Don't call me and put me into trouble. He calls at 21:08. There was no answer. Followed by another call at 21:18. Again, there was no answer. Insisting and insisting to call. And then at 21:30, he sends a WhatsApp asking me to send him my statement I made to the police to his email address. As I said earlier on, Your Worship, there is no way that he can stand here and say, I didn't know who the witness was. Because he has already told the world and the country, you know these people, why they are looking for me. It's because I went to prison and obtained a statement from Mr. Ngengwa. And he knew who assisted him in doing so. This is the person he was calling. Come. Give me that statement that you've made to the police. What bothers me is that he's got the audacity of giving his official email for that statement to be sent, well knowing what he was doing. Fortunately, the witness said to which I did not respond to the message and I did not send him my statement. We are going to court on Monday. We need this statement on Sunday. I don't know what he intended to do. I was looking at Exhibit D. I do not see him disputing this fact. Safe to say, I didn't know it was a witness. That Mali, Your Worship, on the inference, the only irreversible inference who can throw that he knew. That is the second ground. D, because I'm following what the law is saying, one or more. Where there is likelihood that the accused, if he or she were released on bail, will undermine or jeopardize the objective or proper functioning of the criminal justice system. Page 19 of Exhibit GSM5, Your Worship, says the order of the Equality Court. The following order is granted. It is hereby declared that the utterances made by the respondent against the municipal manager of the City of Cape Town, Mr. Lungelo Mbandazayo, Mr. Mbandazayo, constitute unfair discrimination, hate speech, and harassment. 2, this is the court order. The respondent is ordered to remove the social media posts dated 6 February 2023 and 10 March 2023, which contains the prohibited speech by the end of March 2024. Act and do this by the end of March 2024, or rather by the 4th of March 2024. 3, the respondent, Mr. Adams, is ordered to issue an unconditional public apology to Mr. Mbandazayo for the prohibited speech contained in his social media post on the 6th February 2023 and 10 March 2023 by end of 4 March 2024. Second order. 3, the respondent is ordered to enroll for and undertake a program of racial sensitivity training at his own expense by end of 30 May 2024. Importantly, the fourth order, the respondent is ordered to file a report to this court and serve it upon the complainant, evidencing his compliance with paragraph 2, 3, 4 of this order by 31 May 2024. What's his response? Lock me up. I won't apologize to that puss. The Equality Court finds that I've discriminated against the city manager, who's discriminated against me, against us. Fuck the court. I'm not going to apologize to that. I'm not going to mention that name again. Fuck the court. In his exhibit D today, he was going all around saying the PKTT did not comply with the court order, that he went to the High Court of Judge, just forgot the name, may I apologize to the judge, a rule Nisi, where the other parties were not even given a opportunity to respond. But he himself says, I'm aware of this court order, but I'm not going to apologize. Fuck the court. Then the complainant said, okay, you are not apologizing. You are not giving me a report that you have enrolled with the program, we have apologized publicly, we have removed the post. She goes and opens a charge. As evidenced in our affidavit, he himself says it on his paragraph, where he says he's got a case, Cape Town. If I can go to that quickly, Worship. Cape Town Central 311 of 3/2024. Now, has the state not established that he's got a history of giving the courts middle fingers? Your Worship, the court can choose one of the three, because the law allows you to do so. If it has been established, on the two, at least we showed the attempt. On the other one, we proved the existence of his criminal conduct. Going to A, where there is likelihood that the accused, if he or she were released on bail, will endanger the safety of the public, any person against whom the offense in question was allegedly committed, or any other person, or will commit Schedule 1 offense. The very same submissions I've made feature here. I'm not going to apologize to that. Fuck the court. So, and he's not telling you, Your Worship, on his affidavit as to how that matter was resolved. It's not a question of saying it was simply withdrawn. The NPA had to drag him, speak to this man, try to find some common ground. That is evidenced by what? The video footages. He was addicted, if I can use that word, to media frenzy during this time. Every day he would call the media, come, I want to tell you something. He goes to his TikTok and he want to say, he was just addicted on being heard outside there. And in the process, he's calling people names. The Equality Court said, stop doing it. Enroll to a course to deal with your problem. And he said, no, I'm not going to do it. Self-proclaimed people who are criminals and all, that is a member of parliament. And this I understand perfectly why, in his affidavit, he wants to confuse the two issues. On one, he is a member of parliament as appointed by his political party. And he becomes, two, a member of a portfolio committee by virtue of him being a member of parliament. And there are rules and regulations that operate with the committee. It does not take away his responsibility as a party member to go and do whatever he wants to do on the benefit of the party. He can go to Westfield Prison to meet people on the benefit, him as a party member. And say, look, I'm here to understand how are the prison conditions. And then he reports to his party and then they say whatever I want to say. But you cannot come shield yourself as a member of a portfolio committee and do what the job that the portfolio committee did not ask you or mandate you to do. He knew very well, Your Worship, that had he come there as a member of the party, he was not going to get escort. He was not. He was not going to get an official escort because he is as a personal person in his personal capacity as a member of the party. Put loosely, if I can read this. We have collected this evidence so as to put the court at ease. It is important to distinguish between an individual, maybe let me start here. Members of parliament are fully entitled to exercise their constitutional oversight responsibility in terms of the Constitution. In terms of the Constitution and the rules of the National Assembly. However, where a member purports to act on behalf of a portfolio committee or to carry a committee mandate, this requires prior and formal authorization through the committee processes, which we have investigated and established there was none. In terms of the rules of the National Assembly, portfolio committee act through collective decisions of the committee. No decision was taken by the portfolio committee on police authorizing the applicant to act an oversight visit on parliamentary engagement at Westville Prison. None. And he knows it. Is that not a misrepresentation of facts? Your Worship, my colleagues can tell you. I even asked, perhaps we should get a breakdown of what cost did the Metropolis incur to take this man. I mean, petrol is expensive these days. I mean, everybody knows that. For him to be transported from King Shaka to Westville and back, and those members did not have to do their other official duties. Maybe the other members who would have been stuck on the entry, they would have come to assist, but there is this member who says, I'm a member of parliament, here's my identity. He goes in to the prison with the phones, takes a video of the inside of the prison, and does not report back to portfolio committee and say, my fellow members published this. Your Worship, there's a reason why the supplementary affidavit was submitted, which is Exhibit C. This morning, if I can get that Exhibit C. This morning, Your Worship would have listened to one of the video footages. In fact, I don't think it's a video. It's him addressing the media. There was a question and with a journalist, where he says the hitman said in that statement that Dumisani Khumalo had a hand in the killing of Makaka. By virtue of Dumisani Khumalo being in the crime intelligence now. There is nothing on SM7 about Dumisani Khumalo. Nothing. There is nothing on the newspaper article, which he arranged that this statement must be published on, about Dumisani Khumalo and the killing of Makaka. This is the same Dumisani Khumalo who told the family, right from the beginning, I'm the member of this PKTT investigating your matter. Imagine the family reading this and saying, this man lied to us. That is the extent of the distraction or obstructing or defeating the ends of justice. That's the extent. Get your facts correct. Then publish what you know is true. Your Worship, is this the man that is supposed to be granted bail? I beg to differ. One might say, Schedule 1, not serious. Please go deeper. We request, go deeper. You'll see the intention of the applicant. Your Worship, if may I just convene. Forgot to ask to submit one legal thing, Your Worship. It took years for the matter of Senzo Makaka to even start. There were a lot of problems. And eventually in 2023 it started, where charges were put to the accused, including Mr. Ngqeng. And he stood up and said, I'm pleading not guilty. He was legally represented at the time. It was televised nationally. Maybe some of the members who are now televising this were even there in that court, where he said, I'm pleading not guilty. Evidence was laid. In January of 2025, the state was still to lead further evidence. Everybody in the nation knew that man has pleaded not guilty. He goes to prison and obtains this kind of a statement, SM7. And not only obtains it, publicizes it in the middle of a trial that took years to take shape. There was a judge sitting, listening to the evidence. They are co-accused, Mr. Nengwa is charged with, who also pleaded not guilty. and still waiting for the state to lead further evidence to implicate them in the charges. There's a family of the deceased listening to the evidence. He goes on and publishes this. And says, the hit man told me 1, 2, 3, 4, 5. This man has not been found guilty at the time. It's only later, after this statement was published, that he came in and made 220 admissions and pleaded guilty. But at the time, none. And he calls this man a hitman. Your Worship is sitting as a presiding officer. I need not explain myself or make more submissions as to what effect can that do to a presiding officer. They are quite true sitting. They are right. And he goes on his video footages and laughs and make a mockery of what he has done. Those will be my submissions. We've established the existence of at least, oh, I was doing with A when I forgot to make, Your Worship, when we look at paragraph 5, subsection 5, in considering 4A, Your Worship can look at 5C. Any resentment the accused is alleged to harbor against a person against whom the offense in question was allegedly committed, or any other person. We play the video. Who has arrested him? The PKTT. I don't have to interpret what he said. In each and every single footage, you can see the resentment that he has against the PKTT. We submit, we have established the existence of the 4 of the 5 grounds. Bail should be refused. Unless there's anything else, Your Worship, those will be my submissions.